Good afternoon. Welcome to the session on Keeping Up, the Evolving Federal Landscape on Title IX and Sexual Misconduct. My name is Violet Boyer, and I'm the president of Independent Colleges of Washington, and I'm going to introduce our speaker, who is Jennifer Devine. Her bio is on the website, so I'm going to let you read that. What I'm going to tell you is what I know personally of Jennifer. Jennifer is on our board. And she is terrific to work with. She's an attorney in Seattle. One of the conversations I was having earlier today was, do you ask your attorney what you can do, or do you tell them what you want them to do and have them tell you how you can make that happen? What I've found with Jennifer, while she is not our attorney, I have found working with her that she really deeply understands this issue and the nuances of this issue and the details of this issue, but she's also very, very practical. So I think this will be a really good session. There may be some folks straggling in, but it's going to be a pretty deep and dense session, so we don't want to lose any time. We want to get right to it. The one other thing I would say is, while Jennifer is an expert in this area as an attorney, she also has practical experience as a Title IX investigator, so she brings kind of both sides of that to us. So, Jennifer.
You heard who I am. My firm is called Miller Nash, and we're here in Seattle, although we also have a big office in Portland. We do a lot of higher ed work. I want to take a little survey. I'm going to do the campus climate survey first. So, how many lawyers do we have in the room? Okay. I know one of them, so if I want to call on a lawyer, I'll call on her. How many Title IX coordinators? Good part. Okay. How many other campus staff? Okay. How many people I haven't called you out? Okay. Now, the more important question, how many people saw the World Series last night? How many Giants fans? Okay. You I may call on. I'm from Kansas City. And we still think, my whole family thinks Gordon should have gone for home. I thought for the whole time of the game that I didn't know who the pitcher was because my parents just kept talking about that bum Gardner. I finally figured it out. Wait, that's not his name. Okay. So that's the joke for the day. Although I will, if any Kansas City Royals fans, we can commiserate afterwards. So I'm here to talk about the federal landscape on Title IX and sexual misconduct. We have a lot to talk about. It's going to be a kind of speedy run through of the issues. We've tried to, I don't know if anybody's had a chance to look at the PowerPoint. It's up on the website. You can download it, print it out, take it. It's pretty detailed and I think useful. There's a thank you slide at the end, but I will also do it at the beginning, which is I owe a great debt of gratitude to all my NACUA colleagues, the National Association of College and University Attorneys. Probably the lawyers in the room are members. I know the one, Shelley is, I know. And particularly the women who let me use their work off their materials that were presented at the annual conference this summer in Denver. So it's a very collegial group and it makes practicing in the higher ed realm really wonderful. I'm going to talk about the legal background, going to talk about the recent changes to the Clery Act, the Violence Against Women amendments, and the regulations that just were issued, the final regulations, to talk about the White House Not Alone Task Force report, and I'm going to talk about the OCR guidance and particularly the questions and answers. Well, that's a lot, so we don't have a lot of time to go into detail about a lot of the issues, but we'll get done what we can get done, and I am happy to answer questions, follow-up questions by telephone or email afterwards. I can't give legal advice about a particular issue unless you want to retain my firm, in which case we could, but that's a different matter. Okay, Title IX. Sexual misconduct is prohibited by Title IX. This is the entire Title IX. Covers any education program activity receiving federal financial assistance. You can't discriminate on the basis of sex. This is it. This is from whence all the other reams of paper that if you have been working in Title IX, and particularly the coordinators have been reading, comes from. Covers athletics. We all used to think it was mostly covered athletics, discrimination in the STEM programs, pregnancy, which is an issue that you have to be aware of now, and of course sexual harassment, which is why it covers sexual misconduct. Title IX regulations. It's subpart D, the education programs or activities that is pertinent for our purposes. Here's the whole list of areas that are covered by the regulations. And this is the education program or activities reg. This is the only Title IX reg that speaks to our issue, discrimination on the basis of sex in other education programs or activities. Recipients can't, on the basis of sex, treat one person differently from another in determining whether the person satisfies requirements or conditions for aid, benefit, or service, or provide those aids, benefit, or services in a different manner. This is actually the regulation that leads to sexual harassment and sexual misconduct being covered by Title IX, or enforces that. You can't limit any person in the enjoyment of right, privileges, advantages, or opportunities. The Title IX litigation. So initially there was litigation. So, well, let me back up. Before we get into the guidance, the OCR guidance and the administration report, what we used to be worried about prior to the real enforcement actions from the Department of Education was lawsuits from students. Those still exist. I mean, you still have to be worried about lawsuits from students. Back in the 70s, in the Cannon case, the Supreme Court said that you can have a private right of action, so people can sue you under Title IX. In the 90s, the Franklin and Gwinnett, a public school case, the court held that the plaintiff could recover damages in the Title IX case, so you still have to worry about that. And then in the 90s, with the sort of after the sexual harassment issues in Title VII, and that being sex discrimination in the employment field, the court also held that it's sex discrimination, sexual harassment in the education field, Title IX. So there were a couple of cases in the 90s. The Gebser case covered sexual harassment by a teacher. The Davis and Monroe case was the case that said that the institutions can be responsible for peer-on-peer sexual harassment. The good news is that it's a fairly high standard of proof for an individual plaintiff. The institution has to have substantial control over both the harasser and the environment in which the harassment occurred. There has to be actual knowledge. So somebody in the institution, an appropriate person with the authority to take the corrective action and end the harassment, has to know about it. And the harassment has to be severe and pervasive. That's a very similar standard to the Employment Title VII standard. It has to be severe, pervasive, and objectively offensive, and has to have the effect of depriving the victim of equal access to education. And the institution has to show some level of deliberate indifference. Basically, the response has to be clearly unreasonable. It can't be that you were trying to do the right thing and you just didn't get there. That's the standard for a private right of action. That's not the standard that OCR uses. So it's not what we need to worry about these days with respect to government enforcement, but it is still the standard for an action from a student. The courts have since then expanded the definitions a little. The proof of knowledge is not, it can be based on past acts. The Williams case was a case where it was a student who had committed acts of sexual misconduct at a prior institution. The current institution knew about it, and that was held to create knowledge in that institution. The Simpson and University of Boulder, Colorado Boulder case was acts by other students, but on the same campus. So it was actually a football program. There had been so many instances of sexual misconduct that the institution was held that they should have known that it was likely to happen again there. There are still limitations, so the private right of actions aren't expanding it, beyond all reasonableness. It's not unrelated incidents of other on the campus that don't have anything to do. If you have no foreknowledge that just one action here isn't going to give you liability in a completely other area. Again, for a private right of action by a student, that's not the position that OCR would take about whether you're taking sufficient actions under Title IX. Takeaways, you want to make sure that you have prompt, thorough investigations. You want to apply your policies and procedures consistently and equitably. That can be a good defense against either a contract or tort action from students. Now, you still need to worry about, the lawyers in the room now, you still need to worry about suits from an accused student. They can still sue you under a private right cause of action in either contract, saying you promised me in your handbook that you would provide certain conduct procedures and you have done something different. They can still raise that suit, or a negligence action that you are applying your misconduct procedures negligently. So you still have to worry about those. Which is one reason we're here when you work with OCR to live up to the standards that they're requiring. You want to make sure that your policies and procedures reflect that, so you're able to consistently apply those policies fairly. That are consistent. What you do in practice is consistent with what you promise in writing, that you're not facing the lawsuit from the accused student saying you didn't do what it says here you were going to do. Now, moving on to the bulk of what I'm going to be talking about today is the more recent action from the OCR. Let me lay out some of the framework here. I mentioned the regulations, the Title IX regulations at the beginning. As I mentioned, those are very brief, don't give us a lot of guidance. What the detailed guidance comes from is not actual regulations that have been, although now some of them, and we'll talk about that at the end, the Violence Against Women Act regulations, the Clery Act regulations bring a lot of this into actual enacted regulations. But what the OCR documents are, these significant guidance documents are not, they're not enacted, they're not statutes, they're not regulations, but they're what OCR, they're significant significant guidance documents, this sub-regulatory guidance. Well, it's only the lawyers in the room who are going to get excited about this. I mean, what it basically means is we could be challenging some of the stuff that OCR is requiring us to do in this sub-regulatory guidance. But none of your institutions want to take that role, and we don't blame you. The guidance documents are all available on the Department of Ed's website. The address is all of these in the PowerPoint that is available on the website. They're all there's a lot of hyperlinks in that PowerPoint, and they are all supposed to work. They worked when we sent it. Apparently, there was some miscommunication. I think this doesn't work. These don't work, but they will tomorrow. If they haven't already been fixed, they've promised that they will be fixing them tomorrow. I think this HTTP got read as HMP, so even if you copy and paste it, it won't. But you could you could get to it on the Department of Ed. And any of you that, you've probably all been on the website. You've probably all found this already. Any of the Title IX coordinators, if you haven't been on the Department of Education website, you need to go. But the people that are here in the room, I know have been, the ones that I know. I can't speak to the ones that I don't know. Okay, the guidance documents. These are the ones that you need to read. I mean, there's no other, all of this stuff you need to review and be up on. The 2001 guidance is still relevant, the Revised Sexual Harassment Guidance, the first statement by the Department of Ed. That was clarified and kind of enforced a little bit in a Dear Colleague letter in 2006. That really just says, we really meant what we said. The 2008, it's a pamphlet, the sexual harassment, it's not academic. You should also want to look at the 2010 Dear Colleague letter on harassment and bullying, because that is pertinent, and you need to understand what they're saying there. The April 4th, 2011 Dear Colleague letter, this was the one that got everybody's attention back in 2011, where we said, we really mean it. Sexual violence is sexual harassment, it's sex discrimination. You need to take action. Many of our institutions started paying attention and changing your policies and procedures then. There's also this accompanying pamphlet for students that's important to look at the same time, because you need to know what the students are being sent to read, this Know Your Rights pamphlet. The 2013 Dear Colleague letter on retaliation is also something you want to be aware of as you're developing your policies and procedures. And of course, the most recent, April 29th, 2014 Q&A. And that also has this accompanying pamphlet for students. Then the White House Task Force and the Not Alone report. The Not Alone website, many of you have probably already been on it. There's a link here. That one does work. And so hopefully when they fix the other one, they won't unfix this one. If you have any, well, you can get it, but it should hyperlink great there. And I think I also thought it was elsewhere on the website of the conference here. Then Clery Act and the Violence Against Women Act amendments. The important takeaway here, I'm going to go more into depth on each of this stuff, but I want to give the overview before we get there. The important takeaway here is that the Clery Act doesn't change the Title IX obligations. You have to comply with all the laws, and in fact, there's the Clery Act, there's FERPA, and there's Title IX. The Not Alone website actually has a great comparison chart that's well worth downloading and printing out and keeping around. The Violence Against Women Reauthorization Act, the Campus Save Act, which was passed in 2013, amended the Clery Act, added additional reporting obligations. We'll get into those. New student discipline requirements and new training and education requirements. That's all in the Clery Act requirements and what you have required to have in your annual security reports. But that is also a backdoor into actually changing the discipline and the training requirements you have to have on campus. Nothing in the Campus Save Act changes the institution's obligations to comply with Title IX and OCR guidance. And yes, you should be complying with OCR guidance unless you want to be the test case. The Vawa negotiated rulemaking process was an incredibly interesting process. So this was these regulations that implement the amendments to the Clery Act these are regulations. They have the force of law. They are been enacted. You're required to follow them, although they don't become effective. They just came out October 20th. They're published they were published, I mean, the initial ones were published in the Federal Register, and then there was the public comment period, and the final ones just were published October 20th. They don't take effect until next year, so you don't carry legal effect and fines, et cetera, until next year's annual security report, but institutions have to make a good faith effort to comply until then. I think I'll get more into the negotiating rulemaking process at the end. It was very interesting, but let's get there in due course. So let's first talk about the task force. The task force that took place started in January and issued its report in April at the same time as the OCR questions and answers. So this was the Obama administration's effort and action to take sexual assault seriously. It was very high level, co-chaired by the Office of the Vice President and the White House Council on Women and Girls. Members were heads of the departments of many agencies and offices, really high-level group. They met. The mandate was to strengthen federal enforcement and provide schools with tools to help combat sexual assault on your campuses. It was a 90-day national conversation. They had meetings around the country. Thousands of people participated. And the focus was on higher ed. In the Title IX, all the OCR guidance applies to both K-12 and higher ed. The Not Alone task force was focused on higher ed. This isn't law. The function is advisory only. Much of the Not Alone guidance goes into OCR the guidance and the questions and answers. The report was released April 29th, same time as the Q&A. And the idea is really to focus the efforts and show how important the administration considers this issue. Contains a number of action steps and recommendations involved with identifying the problem in these campus climate surveys, preventing sexual assault on campus, and specifically with engaging men, responding effectively when a student's sexually assaulted, talked about the importance of partnering with the community, and then improving the federal government's enforcement efforts and being more transparent in how they're enforcing. First thing they recommended was the campus climate surveys in order to know what the problem is. If you don't know what the problem is, you can't solve the problem. They provide a toolkit on the Not Alone website, a toolkit for putting together your own climate survey, and are calling on schools to voluntarily conduct climate surveys this year. And the statement is, a school that's willing to get an accurate assessment is one that's taking the problem and the solution seriously. So it's not mandatory, but they're heavily suggested by the Not Alone report, heavily suggested by OCR guidance. The report refers back to OCR guidance from the Dear Colleague letter, talking about assessing the effectiveness of your response, and also the Q&A talks about the assessing your climate and getting a sense of the what's actually happening on climate on campus several times. So it's be cautious in just taking the toolkit. I mean, I know many of you are from campuses that are pretty sophisticated and probably have a much better handle on this than others. But you want to not, when you're taking the climate survey, you don't want to make the problem worse. You want to get a handle on the problem. A lot of the questions that are included haven't been validated, and the whole report, the whole survey hasn't been validated. So, make the effort, but don't just dive in wholeheartedly with exactly what they have there. There is more research being done. I think it's Rutgers, but maybe not. I think that's it. And it's the task force report talks about a survey, evidence-based survey that's likely to be mandated in 2016. We'll see if they get there. They actually have to have a survey that they can validate before they can mandate it to be implemented. In any case, it's clear that the prevention efforts need to be a priority. They have a lot of the administration has a number of pilot projects around the country to test different prevention programs, a lot of interest in and work on bystander intervention. I know there have been programs, other sessions here on that. The Center for Disease Control, their website also has a lot of information. They're developing best practices and figuring out what needs to happen to improve research. One of the big issues for the administration, both in the task force report and in OCR guidance, is wanting to give survivors more control over how they report, when they report to whom, and control about confidential reporting if they want to be able to do that. Heavily disfavors making all staff responsible employees who must then report to the Title IX coordinator. So I'm not saying you can't do that, just you would have to really think about that and make sure that a survivor still has a confidential place to go, that he or she can be referred to off campus. Victim advocates are key best practices. I know that I've talked to a number here, and it's something you really want to make sure you have on your campus. The Not Alone report has a sample reporting and confidentiality protocol on the website. I think that if that wasn't up there initially, it's up there now, and you should take a look at that. You want to make sure you adapt it to none of these documents, these sample documents that are up on the website, can be taken and just implemented whole heart, because you won't understand them. I mean, you've got to make sure they actually apply and can be implemented on your campus. So yes, they're suggested, but that doesn't mean they can just be put into force without thinking about it and understanding how they apply. Because you have to, for one thing, you have to train your employees so they actually understand how to handle all of the policies, but particularly the confidentiality protocol. There is also a checklist for a sexual misconduct policy. The sexual misconduct policy, what you really want to make sure you do in developing or checking your current sexual misconduct policy against their recommended policies is to engage your campuses and make sure that you have a large number of different sectors of the campus buying into and helping develop the policy. Again, this is something you want to make work for your campus and have the more people involved, the more different kinds of voices involved, the better your policy is going to be. The policy language, this is all, there's sample definitions and procedures for all of these, the Title IX coordinator, interim and supportive measures for survivors, and definitions of terms, all things that you can look at. And again, you all should have sexual misconduct policies, but it's a way of checking what you have and maybe improving them. Training for school officials, there's a lot of training requirements, and we could do many whole sessions on training. There are some resources that the task force has promised different training resources, but a lot of those haven't been coming along with the speed that they were promising them. There are some more training resources available and are promised yet to be implemented, but it's not quite there yet. There's a pilot course was promised for September. It's now scheduled for November, but it's just a pilot course. It's not something that you can use just wholesale. There is an online training course that they're recommending from the End Violence Against Women International Online Training Institute. It's free. That's the good news. I don't know. Has anybody used it? Anybody know about it? Okay, it's a module course. Multi-hour long, different modules. It's being. OCR is recommending it. We'll see if it's. I haven't tried it. I don't know anybody that's used it, but it's there, and it is a resource that is available. There's some technical assistance, and there's also going to be training materials promised for health center. The task force is heavily suggesting new investigative and adjudicative protocols. The one thing I'll say here is that OCR is, and not alone, the task force report, heavily in favor of a single investigator model rather than a hearing board to investigate and handle sexual misconduct cases. Some campuses are required to have, it's a bigger deal to just change over. So some of us are stuck with hearing panels, but certainly the move is very much toward a single investigator. Partnering with the community, having memorandums of understanding with rape crisis centers is key. You want to make sure that the crisis services are available 24/7. There are sample MOUs available. The transparency. So the Obama administration and OCR is very much trying to move toward being transparent and responding to complaints that you're requiring us to do all this stuff, but you're not telling us really how we're supposed to do it. So which is why there's so much more information available on their websites now. There's a lot. There's a lot more information for students as well. So there's a lot of information there for students, which is great in many respects. It's also something you need to, as administrators, you need to read through all that so you know where they're getting some information, so that you're explaining either, yes, we do that, and this is where we do that here on our campus, or no, we don't do it exactly that way, we do it this way, and this is why. But you need to understand, because this is being seen as information that you must do because the federal government says you must do it. So you want to be aware that it's there. All the OCR current resolution letters and agreements, except ones that really can't be published without invading somebody's privacy, are being published. They're all there on the Department of Education websites. There's the list that every new investigation is there from time to time, giving the list of campuses that they are adding to the list that they're investigating. OCR is investigating with sexual misconduct complaints. They're eventually going to collect and disseminate the list of Title IX coordinators, so you're all going to be up there. There's all the information on the Dear Colleagues letter. They added some changes, a 90-day limit on voluntary resolution agreements, because these used to possibly take months and sometimes even years. So when they found a school in violation, they require, and you want to enter a voluntary resolution agreement rather than an enforcement action, you only have 90 days. So it really brings matters to a crux quickly. We talked about the not alone the Clery chart, the comparison chart. There's also, they have now a memorandum of understanding between the Department of Education, the Office of Civil Rights, and the Department of Justice, Office of Civil Rights. And they have a memorandum of understanding as to how they're going to handle enforcement actions, because it has been confusing. That's up on the Department of Justice website. There's also a memorandum understanding with the Federal Student Aid Office. I'm sure that's up somewhere, but I'm not sure where. The guidance documents. The 2001 guidance remains in full force and effect. So we talked about reviewing that. That is still something you need to pay attention to, as well as the Dear Colleague letter, the 2011 Dear Colleague letter. The Dear Colleague letter raised a lot of issues and questions that weren't clear. This new guidance issued this year, the Q&A, is an attempt to explain and answer some of those questions. Obviously, And in a lot of respects, it does. It really springs from the Dear Colleague letter, but there are, some clear additional requirements that are added on, and you're expected to follow. It's like 50-some pages. You have to read it. All of this stuff you just have to read. It has to be read in full, and it's not. It's readable. It's probably all. It's set out in sections, and questions and answers in these different sections. We're going to go through each of these, so I won't read them to you. You can read. It explains what is sexual violence, and explains how Title IX applies to student-on-student sexual violence. And here's the standard that OCR applies. That if the conduct as to whether a student's rights under Title IX have been violated, so this is a lower standard than for a private right of action in a court by a student. If the alleged conduct is serious, sufficiently serious to limit or deny the student's participation in the school's program, i.e. it's a hostile environment, and the school, upon notice, so you have to have notice, fails to take prompt and effective steps to end the sexual violence, eliminate the hostile environment, prevent its reoccurrence, and remedy its effects. So it explains how each one of those elements needs to be met. The hostile environment is judged from the perspective of a reasonable person in the victim's position, looks at all the facts and circumstances. The more severe the conduct, the less need to show a repetitive series of incidents. So if you're talking about sexually harassing comments, one isn't enough. You're talking about an actual sexual assault, certainly a serious sexual assault, one is enough. You can have notice by seeing something directly or receiving the report directly. You can also have notice indirectly by reading things on a social media site, hearing something from a member of a community, I heard this, media reports. An indirect report doesn't require you to take immediate action, but it does require you to determine whether that's sufficient, whether that indirect report is enough that it should trigger an investigation. So you can't ignore a report that is in the paper. You need to at least analyze it to determine, is this something we need to follow up on? And they can conclude that you have created a hostile environment by not choosing to inquire. We talked about the steps that are required. The important thing is, which I think you all know, is you have to take interim measures. So before you have completed the investigation, right at the beginning, when you receive the report, you need to take interim steps to protect the complainant and provide him or her with updates and let them know where the resources are available for help on your campus or in the community. Title IX covers many people, does cover employees on students, includes child abuse, sexual abuse of children. You need to know your reporting requirements. OCR made clear that they have a strong presumption that any sexual activity between a student and a member of an employee, be that a staff or a faculty member, is non-consensual. So regardless of the age of the student, you can have the policies that you choose to have, but that's OCR's presumption. All kinds of students. So some issues, you have to deal with same-sex complaints. Those are covered by Title IX. You need to make sure that your policies include same-sex examples, if you're including examples of prohibited conduct, and training for investigators and hearing boards on issues relevant to the LGBT community. Students with disabilities are of course, also covered. You need to make sure that your materials are accessible for students with disabilities, as are your reporting and investigation procedures and your trainings. International students, the Q&As talk about international students. You want to make sure that those are accessible, so language interpretation if necessary. Be cautious and be aware and work with your international students office on the visa issues. The non-immigrant statuses may be affected, and if part of the remedy is dropping courses, then you have to be careful about dropping below the visa requirements, and you may need to work with independent studies or something to work around that. But they do talk about that. These are the standard procedures that you have to have in place. The notice of non-discrimination, one employee. Some of you are that one employee to coordinate the Title IX efforts. The published grievance procedures, providing for the prompt and equitable resolution. The coordinator's responsibilities. So this will speak to many of you in the room, how much you have to do. You have to have all reports of sexual misconduct, sexual violence on your campus get to you somehow, so that you're responsible for coordinating all of them. The confidentiality, you want to allow people to have a confidential place to report, but those confidential reporters still need to provide the Title IX coordinator some information about what is being reported. So if there's a particular area of campus that is a problem, that the Title IX coordinator has that information. If there's a team or a club that is a problem, that the Title IX coordinator gets that information. You need to be able to identify the patterns or systemic problems. And it's the Title IX coordinator either needs to be or to delegate the responsibility of evaluating whether you can meet a student's request for confidentiality. If you can't endanger the rest of the campus and the rest of the students in order to protect one student's desire for confidentiality. You're trying to make a place for a confidential report as much as possible, but you have a duty to all your students. The Title IX coordinator is also the person responsible for making sure that your disciplinary process is prompt and equitable, and that the interim relief is being provided. Optional Title IX coordinator responsibilities, these go on. The training, the actual conducting of the investigations, the interim measures, meeting with students, coordinating those policies and procedures, creating the MOUs with the local agencies. Employees who should not serve. So some of you are safe here. General counsel shouldn't. Anybody who has a conflict of interest, that anybody who may be participating in the student conduct process. The grievance procedures. The most important thing in the grievance procedures, and you can read, but is the prompt timeframes and the notice to students about how things are handled and the time frame in which they'll be handled. Both the title, the questions and answers, and now the new Clery Act Vawa regulations talk about the grievance procedures and the requirements in some detail. They need to be impartial. A lot of this comes out of the 2011 Dear Colleague letter, but there are even stronger requirements that you need to have the equal opportunity for both students to participate and to present witnesses and evidence. The notice to the complainant and the alleged perpetrator of the outcome, and an assurance that schools will take steps to prevent the reoccurrence and remedy the effects. Quite a few more required elements. They are listed here, and I'm not going to read all of those. I want to make sure we have time to get to the actual regulations. Some of the important things are making sure students know who is responsible for evaluating the confidentiality request, and making sure that students know and you have provided them clear notice that they have the right to file both a criminal and an internal complaint. And the interim sanctions notice is really important. The Q&A makes clear that it's the preponderance, of this was already from the Dear Colleague letter, but it's even clearer now. You have to apply a preponderance of the evidence standard. That wasn't actually included in the regulations, but it is very clearly in the OCR guidance. In a clear notice about remedies and sanctions, and make sure that students know where they can go to get resources for counseling and support. Due process rights, this is where the publics are kind of, can be stuck between a rock and a hard place. OCR says Title IX has to be interpreted consistently with federally guaranteed due process rights for the accused student, but providing that due process to the student, you can't unnecessarily delay the protections provided to the complainants. So, I mean, a bit you're stuck between a rock and a hard place, but the takeaway is really strong interim measures are required. You don't have to have a separate process to handle sexual misconduct issues. You do have to make sure that the process is prompt and equitable, applies the preponderance of the evidence standard. So if you have another standard that you're using in any other student conduct cases, then you do have to apply the preponderance of the evidence standard to sexual misconduct cases. Okay, responsible employees. There's a lot of detail about responsible employees. Responsible employees are the employees that have to, if they get a report, have to report the incident, the possible incidents to school officials, to the Title IX coordinator, or at least report up eventually to get to the Title IX coordinator. This is what creates the liability if you do not take action when a responsible employee learns of an incident. So who's a responsible employee? An employee who has the authority to take action to redress the sexual violence, an employee who's been given the duty of reporting those incidents, or any employee whom a student could reasonably believe has that authority. So quite likely all professors. It's probably not the line staff in the cafeteria, but it's going to be judged by the facts and circumstances and judged by the reasonable belief of the student and their relationship. So you want to train and make sure that your employees understand and that you're clearly communicating to students who the responsible employees are. And you want to let the responsible employees know who they are and what their responsibilities are, which is just don't make them responsible employees or that category without doing some training. They specifically, and this is the part that's really being emphasized now, is they need to understand what they have to do to report and what their duties are to tell the student about where you go if you don't want this report to go up. So how do you, what are the confidential resources on campus? How does the student make that report if they don't want something to be investigated but they want to talk about it? The responsible employee has to provide all incidents about any possible student-on-student incident. So we talked about this already, that the responsible employee needs to inform the student about confidential resources. Residential advisors, so your RAs are, are they responsible employees or not? And depending on how they're handled on your campus, you really need to think about this and who they are and what their responsibilities are. If they have responsibilities to report and to handle other issues of misconduct, then most likely they're going to be a responsible employee for sexual misconduct issues. Be careful about the confidentiality provisions with the RAs. They need to understand, OCR specifically is talking about requiring RAs to have conversations with students before they report anything that the RA would have to report to the Title IX coordinator. What does the student need to feel safe? What kind of interim measures? Explain that reporting doesn't necessarily mean there'll be an investigation if the student wants confidentiality, and the student's right to both file a Title IX complaint and to report a crime. Okay, moving on. This is the rest of pretty much the rest of the questions and answers. We touched on this, that if the complainant does not want their name disclosed or asks that no investigation be pursued, you want to honor that to the greatest extent possible by making those confidential resources available and by not moving forward if you can keep your campus safe without doing the investigation. You need to tell the person that there's limited steps you can take against the perpetrator if the complainant doesn't want to proceed. But you want to try to do that unless you have to proceed in order to keep the campus safe and prevent further incidents. Even if you're keeping the information confidential and not moving forward against the perpetrator, you still need to provide remedial measures to the complainant. The Q&A goes into some detail about the factors that the Title IX coordinator or his or her delegee is considering and weighing the request for confidentiality. And obviously, one of the biggest issues is, were there credible reports of any prior acts of sexual violence? Because you may need to proceed against alleged perpetrator if you have multiple credible reports. You will need to proceed. Reporting responsibilities are described in some details. So OCR interprets Title IX to give students the latitude not to require certain confidential reporters, the counselors, survivor advocates, not to report incidents in a way that identifies the student without the student's consent. You need to weigh that with the Clery Act timely warning duties. So you have to be aware of both requirements before you can. There's some places you have to walk a little bit of a knife edge there. And you still need to collect aggregate data from the confidential resources so that you can judge where the problems are and identify any systemic issues. Okay, Title IX investigation, adequate, reliable, impartial, and prompt. Interim measures are required and remedial measures to the survivor. One party gets to have an attorney. The other must also be allowed to have an attorney. The Vawa regulations go even further. Attorneys are required to be allowed. You can't ban attorneys, although you can require the potted plant approach, not letting them actually represent the person. If one party gets to submit expert testimony, the other one has to be permitted to do so as well. The key differences between your Title IX investigation and a criminal investigation, the prosecutor gets to decide whether to go forward with a criminal investigation. Lots of cases, it doesn't make sense to go forward with, either because of prosecutorial resources or because it's not a case that is winnable and not something that you necessarily want to put the survivor through. Title IX investigations are not discretionary. We must go forward. Off-campus conduct needs to be investigated, so you need to investigate any conduct that's reported at fraternity houses. Even if it's off-campus conduct that has the off-campus place has no connection with your campus, if there is an effect on the campus that is affecting the survivor's education, you need to take action to investigate that. And even if there's no continuing effects on campus, but it's something that, but it is a kind of conduct that you would take, if you take action against off-campus conduct in other areas, you also have to take action and investigate sexual misconduct. So if you would take disciplinary action against students involved in a bar fight, you also need to take action against a sexual assault report. So you can't exclude sexual misconduct from how you handle any other kind of incidents of misconduct. The hearing procedure itself, if you have not a single investigator model, but a hearing before a board, you don't have to require both parties to be there, but if you're allowing or requiring one, you have to do it for both. You should arrange the hearing so that the survivor doesn't have to face the respondent. You can't require the complainant to be present in order for the proceeding to go forward. Obviously, it may affect the outcome, but you can't make that a requirement. OCR is very, very strongly against student participation in hearing panels. That was a hotly debated topic at the NACWA conference this summer, particularly when the OCR deputy was not present, because there's many schools that strongly believe that the student participation is valuable and is something that they absolutely need. That's, it's not, there are many good reasons to have students on student panels. There's also, but that's not OCR's position. They are, and that's not changing anytime soon. I am apparently ready to be done, or at least talk without, maybe I should do a song and dance up here. Cross-examination. You don't have to require it. It has to be equal if you do allow it. Very strongly discouraging any cross-examination of the reporting party. Sexual history, it's verboten, except sexual history with the accused student, but about anybody else should just not be permitted. You should set up the hearing in a way that doesn't inflict additional trauma on the complainant. Time frame. So the Dear Colleague letter talks about the 60-day time frame. The questions and answers make it clear that includes the investigation and the hearing, but that needs to be completed within the 60 days. The appeal does not have to be finished within the 60 days, so that's an add-on time period. They're also making it clear that this isn't a hard deadline. I mean, if there are reasons that the investigation can't be concluded within 60 days, it's not that you need to rush to judgment and say, oh, we're done, and we have to do this. If it's over the summer break, I mean, you should try to keep things moving, but if it can't be finished, it can't be finished, and they won't, it's not a statute of limitations period, as we lawyers would like to say. But even more so, I mean, you need to make sure that if particularly the longer a process goes, that your interim measures are in effect, are working, and are extended, and have the check-ins back with the survivor that are there any additional interim measures that are needed. Again, remedial measures should be both interim and post-investigation remedial measures should be implemented even when a student requests confidentiality. You may not be able to sanction the alleged perpetrator, but you can still provide measures to protect the complainant and ensure that he or she can get access to the education they want to. How do you determine what interim measures? It's very fact dependent, depending on what do they have classes together? Are they both living on campus? Neither living on campus? It's not rocket science. It's just paying attention. Don't move the complainant. Move the perpetrator, the alleged perpetrator, unless the complainant asks to be moved. I mean, you don't want to have the have the process negatively impact the complainant unless he or she actually wants that to happen. Counseling, the OCR says that you actually have to provide counseling if the counseling is a required interim or remedial measure. You need to do that without charge to the complainant, even if you have a fee per service on the campus. Some of us think that's a little much, but that's what it says. Remedies, we talked about that a little bit. So after the investigation, think again about remedies. Even if the complainant didn't want interim measures, you need to loop back and determine what they may need now. They may, people change, and particularly people who have been traumatized, so they may now discover that there are additional measures that they want. Here are some of the measures. I'm going to get through some of this because I've still got some things at the end. It always takes longer than I want it to. The notice of outcome needs to be provided to the complainant. The appeal process should be, you don't have to have an appeal process. If you do have one, it needs to be equal. Then the hearing appeals panel or individual should also be trained on sexual violence dynamics. The types of training that should be provided. You need to train all employees on how to prevent and identify sexual violence and how to respond to reports on a regular basis. For the employees that are involved in implementing the grievance procedures, there's additional training requirements on the standard of review, working with people subjected to sexual violence, consent, the role of alcohol and drugs, credibility, how to evaluate evidence and weigh it, the effect of trauma, including any neurobiological change on a victim or survivor. That training should happen on a regular basis. Students need to be trained on how to report confidentially if they choose to, what your school's definition of consent is, and examples. And that's, as I'm sure all of you know, a hot topic, and what kind of consent definition you have. How your grievance procedures need to be clear, communicated. Students need to understand that. They also need to train students on the effect of trauma and the role of alcohol and drugs, and also bystander strategies, protections against retaliation, and those students should be trained at regular intervals too. Title IX protects against retaliation. Students need to understand, you need to tell them and guarantee that they won't be retaliated against if they make a Title IX complaint or they're involved in the process. The Q&As don't address the situation of where the alleged perpetrator is being retaliated against. But you do need to, Title IX, remember, protects all your students. it prevents gender discrimination. So you can't protect the traditionally female survivors and not protect your male students. So you need to think about, let respondents know they can report retaliation, and OCR will investigate situations of retaliation against alleged perpetrators. So you need to think about how to handle that in advance. Okay, there's some additional issues covered in the questions and answers. The First Amendment issues, the Title IX and OCR's guidance doesn't affect speech. At least it's not supposed to. We could do a whole session on academic freedom and the First Amendment. The Clery Act, we already talked about, doesn't alter the Title IX obligations. Okay, the Vawa regulations. I promised I would talk about this. I'm gonna be able to just touch on it before we finish, but I urge you to review the PowerPoint and the slides on the website and download them. Or if you have any problems with anything, feel free to email me and I will get it to you. So if you haven't read the new regulations, you need to. They're not effective until next year, but you're required to make a good faith effort to comply, which has already been in effect with the statutory change. So they add reporting of domestic violence, dating violence, and stalking, as well as sexual assault, which was already there. New student discipline requirements and additional training and education mandates. The negotiated rule making I alluded to earlier. There were representatives from the Department of Education and also campus representatives from different kinds of institutions, and there were 2 NACWA members who participated from the National Association of College and Independent Colleges, I think, and had some. So they were negotiated. The campus council who were participating in that process consented to everything that was in the final regulations. It doesn't mean they necessarily agreed with them, but they got the best result that they could, and so they're better than they could have been. I am out of time. I think a lot of this is fairly well covered in the slides themselves, and I think will help. I think if you go through the slides on your own, it will help you review the regulations, because regulations are hard enough for lawyers to read, much less non-lawyers. It's not that all of you aren't completely smart. It is that we managed to write regulations in ways that loop back. So the regulations have change the definitions, specify the definitions of sexual assault. It does not include, there's no regulatory definition of consent. You have to train on both your jurisdictional definition of consent and on your institution definition of consent. But there's no required, the regulations do not include the affirmative, unambiguous, and voluntary agreement to engage in a specific sexual activity that was suggested. OCR is going to have guidance that's going to be pushing schools to that definition, but it's not in the regulations. So all of these, this is for the Clery Act reporting, but what the regulations also do is add a whole bunch of stuff that needs to be in your annual security report. And so this is how they loop back in, and it's kind of backdoor way of requiring more of the same kind of requirements that are in the OCR guidance. The training and the policies and procedures, and what victims procedures you have to have, and what kind of disciplinary proceedings you have to have. And they also prohibit retaliation. Thank you.